So good afternoon, everyone. Welcome to our Tenants' Rights During the COVID-19 Crisis program. I'm State Senator Shelley B, representing the 37th Senate District. And as we get going, if you wish to hear this program translated live into Spanish, you must join us on the Zoom webinar. The link can be found on my Facebook page, State Senator Shelley B, or if you are on the Zoom conference call now, you will hear contemporaneous Spanish translation, courtesy of two fantastic interpreters provided by the New York State Senate, Juan Carlos Castaneda and Raúl Carrera.
Sí, buenas tardes a todos de parte de la senadora Shelley B. Esta es una sesión para los temas de las asistencias que se le puede dar a los inquilinos. De parte de la senadora se le quiere informar al público que existe un canal para escuchar la interpretación en vivo en español. En la parte inferior de la pantalla está un botón que dice interpretación y usted puede escoger el idioma español. También la senadora les invita a que entren en la página de Facebook y ustedes también pueden tener allí el acceso a la información. Muchas gracias.
Gracias. So let me outline one, why we're here today, and two, how the program will work. We have fantastic panelists here representing legal services of the Hudson Valley, and the Chief Executive Officer is Rachel Halprin. The Hudson Valley Justice Center with the Executive Director Virginia Folkrode. We have Blanca Lopez representing County Executive George Latimer. And the reason that we are doing this program, and I will go through all the panelists, is because the issues of housing during COVID, particularly rental housing, which is what we are focused on today, are absolutely critical to my district, which runs from the Bronx border in Yonkers to the border of Bedford and Connecticut. One of the most important things that people do not always realize is that the suburbs, like Westchester, are full of rental housing, which is one of the few remaining affordable ways to live in the suburbs. And in fact, according to the report done by the County Executive's Office on the supply of housing in Westchester, approximately 38% of Westchester residents live in rental housing. That is approximately 133,000 renter-occupied units. And as someone who formerly represented Yonkers and now represents a diverse district, including Rye, where approximately 1/4 of the residents live in rental housing, the issues of rental housing during a COVID emergency have been critical since last March and remain at the top of the agenda. Some of the issues that we are going to discuss today, and I'm so fortunate to have some fantastic attorneys from these two programs, which I will describe. We are going to talk about the current state of the eviction moratoriums in the federal and in the new state law that was passed at the end of December, called the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. Again, focused on rental housing, although I will talk about homeowner, occupied, and owned housing as a subset of issues. We're going to talk about some of the Westchester County Court procedures and how that has transpired. We're going to talk about tenants' rights and defenses. We're going to also talk about tenants' rights to heat, hot water, and repairs. How to get help with paying rent arrears and ongoing rent obligations. How can undocumented residents feel comfortable and secure in their housing? And the issues of the Westchester Right to Counsel Coalition, which is fighting for every tenant, rental tenant, to have provided lawyers for them when they appear in court, as is the case in the city of New York, but not currently in Westchester. I want to talk a little bit briefly about some of the challenges that led to the passage of this bill at the end of December. Earlier in the session, the legislature tried to allocate money that we got from the federal government to be used to help tenants actually pay their landlords, so landlords would not be out the money during the course of the summer. The program had many pitfalls. There was not enough money, and the burdens were great for tenants to fill out the paperwork. That process has been improved, but it is still a drop in the bucket and does not help enough tenants and does not help enough landlords. We are very mindful that this period poses great challenges to people who own particularly small numbers of units of buildings, who are losing rent, who have to pay their mortgage and their property tax and insurance. This is a trying time for everyone. And in the bill that we passed, not only did we issue protections for rental tenants by providing that they had to sign a declaration that COVID impacted their ability to pay, we also provided some protections for small homeowners, those that own 10 or fewer units, one of which is owner occupied. So if you own 10 or fewer units and you have rental tenants, you also would be protected by a moratorium on foreclosure, by whoever holds the mortgage, and by a tax lien sale. So none of these are perfect solutions. We are in a crisis, and we recognize that rental tenants are at the front end of the risk of eviction, which the CDC decided and determined not only poses challenges to people about where they live, but actual health risks to people during COVID, that the risk of eviction actually itself has health implications for families, particularly those with children. So we tried to come up with a compromise that addressed our concern that people would be thrown out during COVID and have to find an alternative place to live while they lost their job and perhaps their kids were home from school, as well as trying to provide some protections for small landlords to ensure that they did not lose their property by virtue of a foreclosure proceeding. I want to also point out that before I voted on this bill, I asked my colleagues at Legal Services what was really going on in the courts of Westchester. And at the end of 2020, there were 1,000 at least pending eviction proceedings, even during COVID, that were on the calendar in our courts. Some were proceeding, some were not proceeding. And there also were eviction warrants issued when people failed to appear. So the threat is real. This was a pragmatic, constructive compromise to protect tenants and, as I say, to protect landlords. So with that introductory remark, and I see we already, if you have questions, I think I'll get this right for housekeeping, please put them in the Q&A if you are on the Zoom, and I will read these questions. And if you are on Facebook, you can put your questions in Facebook and we will, they will be sent to me and put here on the screen. Is there any way to join without registering? Some people are trying to connect, but they don't have emails. I believe that you can just watch on the Facebook page and you do not need an email to simply watch. Go to my page, State Senator Shelley Mayer, and you can watch this, this program and hopefully learn. This goes from 4 to 5:30. We have some fantastic guests and I'm going to turn to them now. So first we have Legal Services of the Hudson Valley, and Marcy Kobach is going to introduce our guests. But for those who don't know, and I know very well because I've worked with them for many years, Legal Services of the Hudson Valley provides civil legal services. That's not criminal. The difference is criminal versus civil. Civil is in a civil court. It's not a crime, but issues of eviction are civil legal proceedings to income eligible clients in the 7 counties of the lower Hudson Valley. In Westchester, they have offices in White Plains, Yonkers, Mount Vernon, and Peekskill. They represent clients in housing, family law, benefits, disability, education law, and other areas. And I'll let Marcy introduce her colleagues when we get to that. The Hudson Valley Justice Center offers direct representation and advice to low-income residents of the Hudson Valley, regardless of immigration status. And that is because, as a practical matter, many of our neighbors who may have, the parents may be undocumented or one parent may be, would not always be eligible for the services of legal services of the Hudson Valley. So the Hudson Valley Justice Center provides legal representation to individuals regardless of immigration status. They focus on eviction defense and other landlord-tenant disputes, domestic violence, benefits, immigration, and family law matters. Here from the Hudson Valley Justice Center are Jason Mays and Cynthia Tejada. And as I explained, Blanca Lopez, my friend, and I'm sitting here in Portchester, a Portchester person, very important place for rental housing really matters, is the special advisor to the county executive on fair and affordable housing. I do want to thank my staff, Mary Ann Joyce, my director of constituent affairs, and an attorney and my special counsel, who deals every day with tenants on the phone and landlords, helping people through this process of dealing with COVID. Every one of us knows what an incredible toll this has taken on our communities, on families, on our schools as the chair of the education committee, on our restaurants and on our employees. It has been an absolutely devastating set of events. And I want to give thanks to Governor Cuomo for his leadership, and also, of course, to County Executive George Latimer, who has been a colleague and a friend of mine as we go through this and do the best we can. Not perfectly, but the best we can. I also want to thank Emiliana Ulay of my staff, who helped organize all the logistics and made sure that we had a translated Spanish contemporary translation service, which to me, as someone who represents Westchester, where a quarter of our residents are Latino or Spanish speaking, is essential for us to talk about these issues. So with that, unless there is another question in the chat that requires a Facebook account is not needed to watch, thank you. And another advice from Emiliana to all our speakers, please try to speak at a moderate pace so our translators have time to translate. I hope that I did not speak too quickly. With that, I'm going to turn it over to Marcy Kobach, who's going to walk us through, I believe, a PowerPoint with her colleagues. And we will have time, absolutely, after Blanca goes at the end for questions and answers.
Thank you, Senator Mayer, and thank you to you and your staff for setting up this event, which is obviously critical and critically timed. So I'm beginning the slideshow mode. And as we will be discussing tenants' rights during the COVID crisis, I'll be joined by Jason from Hudson Valley Justice Center, my colleague Michelle Avery from the Mount Vernon office, Alexander Brandeis from the White Plains office, and as well from the White Plains office, Lauren Johnson and Alexandra Schweitzer. So these are all lawyers who we'll be speaking to, but they'll be providing information. This shouldn't be construed as legal advice. These are important distinctions that we need to make. And then also just be aware, particularly if you may be accessing this presentation after the event on the 13th, that things are always subject to change. We've seen that happen maybe a little bit even more rapidly during COVID. So it's just always important to, if you have an individual situation, to try and access an attorney to speak about that individual situation. And Senator Mayer introduced us very well with who we are and what we do here at Legal Services. We do provide advice on housing issues, represent tenants, as well as other civil legal issues people may have. We have a general intake line, and also our offices all have direct phone numbers, but during just the challenging times that we're in, we also created a hotline, an eviction prevention hotline, people that have a direct line to go to that was dedicated to doing our quick intake process to get people connected to an attorney for assistance with eviction related issues. And with that, I will turn it over to Jason Mays.
I would also like to thank Shelley Mayer for inviting us. This is really a great event. We are, like Legal Services of the Hudson Valley, a nonprofit law firm. We can help virtually
Excuse
anyone.
me, you got to slow down, I'm sure, Jason.
Okay.
Translators
Thank you.
Understand.
So we provide free legal services, civil legal services to virtually anyone whose income is below a certain level. Because of our funding, we can help people who are undocumented. And as far as we're aware, we're the only people in Westchester County that can represent undocumented tenants in landlord-tenant matters. There are only 2 attorneys at our office that are doing that right now. We're hiring another one soon, but that, you know, we think it's a real shame that there's only 2 attorneys helping undocumented people in landlord-tenant cases right now. The best way for people to get in touch with us is to just call our office. You can call the number there that you see on your screen, 914-308-3490, dial extension 4 for an intake. You can also reach us by email if you just Google, you know, Hudson Valley Justice Center. Our website will come up, and you can reach us that way.
Jason, I'm going to sound like an older grandmother, which I am, but you have to be slower.
Okay. Thank you.
Sorry.
No problem. Thank you. So the senator also ran through the topics we'd be discussing today briefly, but I'll just review them. So we'll be talking about the new law that was passed at the end of last year, the COVID-19 Emergency Eviction and Foreclosure Prevention Act. We will talk about other measures that are affecting proceedings in New York. We'll talk about Westchester County housing court procedures, tenants' rights and defenses, tenants' rights to essential services such as heat, hot water, and repairs. We will talk about how tenants might get assistance paying arrears. We'll talk about the help available for undocumented tenants. And briefly, I'll just tell everyone about the Westchester County Right to Counsel campaign and how you can get involved. And I think we'll hand it over to Michelle for the discussion of the new law.
Good afternoon, everyone. My name is Michelle Avery. Thank you for this opportunity, Senator Mayer. We are grateful to be able to speak to our clients and prospective clients about all these measures that are affecting eviction proceedings. I am a housing attorney with the Legal Services of the Hudson Valley's Mount Vernon office, and I'm here to discuss with you today the most recent piece of legislation that was passed in New York State called the COVID-19 Emergency Eviction and Foreclosure Prevention Act of 2020. This act, also known as SEFPA, and you can consider my segment the appetizer. My colleagues are going to present the entree to you later on. But this act was enacted during an emergency session of the New York State Legislature on December 28th of 2020. And we're all aware that a staggering number of individuals and families were adversely impacted because of due to the onset of the COVID-19 pandemic. And in my personal opinion, nothing paints a more vivid picture than statistics. So I'd like to take a brief moment just to go over the numbers with you. We know that countless tenants in New York State are facing eviction, but we're in Westchester County, so I'd like to focus on 2 cities in particular. I would like to focus on New Rochelle and Mount Vernon. So let's start with New Rochelle. New Rochelle is the 7th largest city in New York. Mount Vernon is the 8th largest city in New York. New Rochelle has a population of approximately 78,000 residents. And Mount Vernon has a population of approximately 67,000. In terms of the housing market data, the number of housing units occupied by tenants in New Rochelle is approximately 14,000. And for Mount Vernon, that's approximately 16,000 housing units that's occupied by tenants. Just to get a nice understanding of the household size, the average renter household size is 2.5 in New Rochelle, New York, and 2.3 in Mount Vernon, New York. And just so we have a clear picture of how many people in New Rochelle and in Mount Vernon own their own homes as opposed to rent their own homes, it's always good to look at the home ownership rates. And for New Rochelle, that hovers around 51%. And for Mount Vernon, the numbers are even more dismal, unfortunately, and that's around 37.8%. So just imagine with me, which is really insane, uh, the number of people that were facing eviction, okay? In New Rochelle, nearly half of the population is comprised of tenants. And in Mount Vernon, nearly 60% of the population consists of tenants. So is there any wonder why this law was passed and signed by Governor Cuomo the same day? Now, as I mentioned, the court moved very rapidly and they posted their administrative orders, their memorandums, their forms for tenants to access on December 31st. And what does SEFPA do, essentially? It addresses eviction proceedings at every stage. It protects tenants that fall within certain categories. So for example, tenants who are behind on their rent, we know that tenants who can't move, unfortunately, because they've experienced a hardship, they've lost their job, their unemployment benefits is not enough for them to cover their rent, so they can't move for those reasons. Or for tenants where the actual act of relocating is dangerous. The tenant is their immune system is compromised. They are suffering from an underlying condition. They have a chronic illness. They have an elderly family member that's over 65 that's residing in their home. And so for those individuals, moving is out of the question. So the intent of SEFPA is essentially to avoid as many evictions and foreclosures as possible for the people in the above categories that I listed. Thank you, Marcy. So what happens to eviction cases that are pending? Most specifically, eviction cases that were commenced before December 28th. What happens to those cases? Those cases are stayed for 60 days. In other words, that means they're put on hold, they're paused for 60 days, and the 60-day stay terminates the end of February 26th of this year. In the interim, what the court is tasked with doing is sending a hardship declaration form to all the tenants who are currently in court. Now, the eviction cases where a judgment was already entered, then a status conference is going to be held and those cases will continue to be heard by the court in accordance to the law. Now, for tenants who submit a hardship declaration form, the next step is for the court to determine if they're creating a nuisance, if they're objectionable, their behavior rises to the level of a nuisance or they're a safety hazard. If the court deems that they are not, then they're protected from eviction. They're granted an additional stay and they cannot be evicted until May 1st of this year. Now, until January 28th, because there will be some landlords that want to file new petitions, but they're responsible for doing it, they're taking additional steps. So if they want to start a new case, they have to send the hardship declaration form to their tenants, in addition to the pre-court notice that they're already responsible for sending. I do want to pause just to define a little bit what that means, pre-court notice. It's the notice that you're supposed to receive before an eviction proceeding can be brought against you. Okay, so if you're facing a non-payment eviction, that's because your landlord is seeking the money that they're owed. They want to recover that. They're supposed to give you So
I think Michelle
a
froze.
14-day
Oh, there
rent
she is.
demand. Now, in accordance with the declaration form. I'm sorry? Oh, was I breaking up?
You froze for a moment, but I think we're good.
Oh, okay, I apologize, everyone. So just to kind of cover, I don't know
And
which.
Michelle, excuse me, I'm sorry. I have a request to speak louder.
Oh, okay, that's fine. I can do that. So I was discussing the last part of my slide, which was when landlords want to bring a new eviction proceeding, what they have to do. And this is until January 28th. They have to send the hardship declaration form in addition to the pre-court notice. And the pre-court notice is the notice that a tenant is entitled to receiving before an eviction proceeding can be brought against them. So if they're facing a non-payment, they're supposed to be served a 14-day rent demand. In addition to that, they will also receive the hardship declaration form for new cases. Likewise, with holdover cases, when the landlord is interested in getting possession of the property, they want the unit back. It's not so much their focus, for them to be concerned about the rent. They want the actual unit back. They're going to receive another type of notice. And that notice, they're supposed to get advance notice, that notice in a certain number of days, like a notice of termination, and that hinges on how long they've occupied the premises or how long their lease is, whichever is longer. But assuming that they receive the proper notice for a holdover, that's also supposed to be accompanied by the hardship declaration form. Now, once the tenant signs the declaration form, returns it to the court, then the new case cannot start until May 1st. Now, there are exceptions, and the exception being the landlord has to attest, and they have to prove these allegations, that the tenant is creating a nuisance, the tenant is a safety hazard, and then the case can proceed. So that's SIFA in a nutshell. I'm going to pass my virtual microphone over to my colleague, Alexander Brandis, and he's going to cover the SIFA declaration form with you. He'll also discuss financial hardship and other measures affecting eviction proceedings in more detail. Thank you, everyone.
Thank you, Michelle. Can I just clarify for everybody who's not so sophisticated, when you say SIFA, you are taking the initials of the
Yes.
COVID Emergency Eviction and Foreclosure Prevention Act and putting it into a little word for your shorthand.
Right.
And I'm glad we're going to go through the actual declaration form, and I'm glad that you referenced that there is an exception for a tenant that under certain circumstances who is really a problem tenant, which I assume you will go through. So thank you for that.
Okay, thank you, Michelle. Thank you, Senator Mayer, and for everyone who helped put this program together. And thank you to everyone who's watching. I hope that it's helpful. My name is Alex Brandis. I am a staff attorney in the White Plains office of Legal Services of the Hudson Valley. And I will be starting off here talking about the hardship declaration form and other measures. A staff attorney in the White Plains. Okay. So yes, the COVID Emergency Eviction and Foreclosure Prevention Act of 2020, for short, we can call that CEFPA. That's C-E-E-F-P-A, CEFPA. Before I get to it, I see that there's a question in the chat. I will take a shot at answering, asking, can you explain how stimulus monies and increased unemployment benefits affect people whose rent is based on their income? I'm pretty sure that, not 100% certain, but pretty sure that the last time there were increased unemployment benefits, public housing authorities were directed to not count that as an increase in income because they were understood to be temporary. So just because your income increased with an increase in unemployment benefits, your personal rent share, if your rent share is tied to your income, did not have a corresponding increase or was not supposed to. And with respect to a stimulus payment, I believe that that kind of one-time windfall should not count as a change in income for purposes of changing your rent share as calculated by a public housing authority either. I do want to say though that if you have any changes to your income and your rent is based on your income, you should report it to your public housing authority. If you have any concerns about what the public housing authority does with that information in terms of raising your rent, feel free to reach out to legal services with that issue. We can look into it if you are eligible for our services. Back to SEIFPA. The hardship declaration, as Michelle was saying, once it has been submitted to the court or to the landlord or to the marshal who is executing a warrant of eviction, is supposed to serve to put the eviction proceeding on hold until May 1st. It is a eviction prevention tool that the legislature has devised to really put a halt to most evictions during this time period when the health crisis is really very even more serious than at certain points in the past. There is an exception, as Michelle mentioned, for people who are an ongoing nuisance, who are, I don't have the language in front of me, but a threat or in other ways bother their neighbors and the right to enjoy the property that everybody should share. But even if well, I don't want to get ahead. That may be part of the presentation coming up later. So to the hardship form, if it applies to you and if you are at risk of eviction, you should sign it. You can give it to your landlord. If you're in a court proceeding, you can give it to the court and it should put things on hold. I'll start at the end of it, which says that I understand that I must comply with all other lawful terms of my tenancy, lease agreement, or similar contract. It says I understand that I'm still responsible for paying rent and that my landlord can try and evict me after May 1st for rent that comes due at any time that is unpaid. What the form does not protect you against eviction or eliminate your obligation to pay rent. It simply postpones eviction proceedings for tenants who are not an ongoing nuisance until May 1st. So you can sign the form if one of two things applies to you. One would be that moving is a health risk. Reading off the form, it says vacating the premises and moving into new permanent housing would pose a significant health risk because I or a member of my household have an increased risk for illness or death from COVID-19 due to being over 65 years old, that's 65 years old, having a disability or an underlying medical condition, including being immunocompromised. So if you are at a health risk, if you were to move, if you were to be forced to move, you can, because of one of those conditions, a disability, advanced age, an underlying medical condition, you can check that box and you don't need to worry about box A. You can check box B and submit the form. You can check box A as well if that applies to you also, but you only need to check one of the boxes for the form to be valid. Before I get to box A, let me mention also this form, if you are looking for it, is available on nycourts.gov. That's nycourts, nycourts.gov. If you click on a box right in the middle, important eviction foreclosure legislation, and scroll down, you will see the hardship declaration in English and Spanish. So financial hardship means you're unable to pay the rent or obtain suitable alternative housing due to specific circumstances. Again, unable to pay the rent or move to suitable alternative housing based on certain circumstances. And they are broad circumstances. It can be a significant loss of household income during COVID, an increase in out-of-pocket expenses related to performing essential work or related to the health impacts during COVID. So if you've lost income, if you've had increased expenses, either of which are attributable to COVID, this would apply to you. Also, if you have childcare responsibilities or responsibilities to care for other members of your family, that have negatively affected your ability or the ability of someone in your household to earn income, or that have increased your out-of-pocket expenses. It's a little bit similar to the first two. Anything related to a loss in income, an increase in expenses because of the health crisis, you can check box A and return the form to the court or to your landlord and get the stay of the proceeding if one is pending. Also, if you're somebody who is looking to or needing to move to a different residence because you're for whatever reason that you're unable to stay where you are in the long term, but you are unable to move immediately. Box 4 on this form says moving expenses and difficulty that I have securing alternative housing make it a hardship for me to relocate to another residence during the COVID-19 pandemic. So expenses or challenges associated with moving, if that is causing you to be unable to move, that would apply to you, and you could check that box A to declare that you have a hardship during this COVID-19 pandemic. And then the last one.
Y después la última.
The last one is.
La última es.
Oh, I'm sorry. I think Raul, or you're not muted in the rest of the. You have to change.
I was just switching interpreters.
Okay, I'm sorry, Liliana. Keep going. I apologize.
Okay. No worries. Thank you so much to the translators as well, who I did not thank earlier. Other circumstances related to COVID-19 that have negatively affected my ability to obtain employment or earn income, or that have significantly reduced my household income or significantly increased my expenses. So they're really saying it in as many ways as they can. If your household income has been reduced or your household expenses have increased as a result of COVID and it has impacted your ability to pay your rent, then you could sign this form. One other important point, though, is that language directly on the form that you need to be able to swear to says specifically, to the extent that I have lost income or had increased expenses, any substitute income, any public assistance, any unemployment assistance, pandemic assistance, disability insurance, paid family leave, any substitute sources of income that you have had, all of those things you have to swear do not fully make up for your loss of income or increased expenses. In other words, you have not been made whole. There have been all kinds of programs that maybe some of you have been able to take advantage of, or maybe not, that are intended to close that gap that so many people are experiencing between their financial picture before and their financial picture during COVID. Things have become a lot tighter in a lot of households, and the government has taken some steps to try and fill in those gaps. If those gaps have completely filled in have been completely filled in for your household, then you cannot sign this form. But if there is any kind of gap still, if you still have less disposable income, less ability to pay rent than you did before COVID, then you can sign this form. That's pretty much it on the form. If it is true of you, if what the form says is, if it would be true and accurate for you to sign it, you can sign it. If you sign it untruthfully, you would be doing so in violation of law. So that is the last piece of the form. So I'll go through quickly as well a couple of other eviction prevention laws that have been, laws and orders that have been in effect at various times since March. One significant one is the Tenant Safe Harbor Act in New York State. That's a New York State law. The significance of it, as compared with what I was describing with SIFPA, is that it does not expire on May 1st. The Tenant Safe Harbor Act does not expire until all of the laws and executive orders that limit public gatherings have been canceled. So the Tenant Safe Harbor Act will remain in effect until that presumably later date beyond May 1st. What the Tenant Safe Harbor Act does is, again, it does not eliminate your obligation to pay rent. You're still responsible for paying your landlord whatever you agreed to pay in your lease or your tenancy agreement. But for any rent that you are unable to pay during that COVID period, until those public gathering restrictions have been lifted, the landlord, if you raise that as a defense, the landlord could not evict you for that debt. You would owe that debt. It would be more like a debt that you owe to, say, a credit card company or a medical provider or another creditor that is not your landlord. They could get a judgment. They could garnish wages or unprotected assets until that judgment is satisfied. But if you raise the Tenant Safe Harbor Act as a defense, they should not be able to evict you for rent that has come due during the COVID period if you have suffered a financial hardship. Again, that's the key to it, if you have suffered a financial hardship. And according to SIFPA, as I read it, if you submit your hardship declaration, you are raising that defense, which can be rebutted, it can be challenged, but you will have been considered to raise that defense just by filing that form. I don't want to take up too much more time. The Emergency Rent Relief Act was a program that New York State funded to pay landlords directly for the increased rent burden that certain tenants experienced just for the months of, I believe, April through July. That program has been extended. You can still apply for it to have your landlord paid some portion of your rent for those months. And those payments would be credited against any account balance you have. Or if you don't have an account balance, they would be considered a credit towards, I guess, future month's rent. That would be, it gets paid, if you're eligible for it, it's supposed to get paid even if you have paid all of the rent that you owe. A lot of people certainly ask me about the CDC moratorium. The CDC moratorium is similar to the Tenant Safe Harbor Act that I was describing. It expires though on January 31st. What the CDC moratorium did was to postpone any evictions for anyone suffering a financial hardship as a result of COVID. Like the hardship declaration that I spoke about a minute ago, the CDC moratorium required tenants to sign a declaration that said, among other things, that I am using best efforts to make timely partial payments that are as close to the full payment as my circumstances permit. So the CDC required tenants to make every possible payment towards their rent in order to get the protections of the law, which it's my understanding the hardship declaration and the Tenant Safe Harbor Act in New York State do not require. In addition to all of that, there have been a lot of executive orders and administrative orders about court access. The courts have been have had their access shut down or limited substantially at various times in various ways over these months. You know, that continues to be something that everyone should be aware of, whether the courts remain open on any given day. But that was an overview of the CFPA and the Tenant Safe Harbor Act, as well as the CDC moratorium. So I will pass the baton on to my colleague, Lauren Johnson, to talk about additional laws, procedures, rights, and defenses in eviction proceedings here in Westchester County. Thank you, everyone.
So Lauren, I just would ask that I want to leave enough time for questions at the end. So if you can go promptly, and I also certainly want to have Blanca have a chance to talk as well. You're muted, you're muted, you're muted.
I'll be as prompt as I can while not speaking too quickly.
All right, thank
So
you.
in Westchester, we primarily saw the courts close down around March 17th. What the courts in Westchester did was take the time to administratively adjourn cases. During that period, the duration, and still even today, the duration of the COVID pandemic is up in the air. So what they did was send out notices to adjourn to May, June, and then July. In July, the court started to bring back landlords and tenants both in person, and some courts in Westchester set up their virtual conferences. In March, there were thousands of landlord tenant cases that were unresolved. And in July, when new filings were being accepted, thousands of more were filed in between July and when CFA has been enacted in December 2020, December 28th. Now that CFA has been enacted, some courts in Westchester have taken the initiative and have been sending out adjournment notices, adjourning until what we've seen is mid-March, around March 17th, to observe the 60-day stay period. And courts have also been attaching the tenant declarations. Another thing that we have seen with these cases that have been scheduled for appearances in early January is that courts are going forward with the appearances virtually for cases that have two attorneys representing, one the landlord and one the tenant. And usually on those hearings, it's been in my experience, and I've appeared in about 5 village and justice courts since this act has been passed, that they are observing and are granting the 60-day adjournment to allow for counsel to submit the declaration on behalf of the tenant. I've also seen in cases, courts are providing the declarations to tenants who don't have the capability to appear virtually and have been appearing in person. I'm going to talk about some of the types of evictions that there are. We like to break it down into 3 categories. So there's eviction for non-payment of rent, a holdover eviction for lease expiration or termination of a month-to-month tenancy, or if permission to occupy the premises has been withdrawn, And the third type that we like to separate it into would be if there was a breach of the lease or a lease violation or creating a type of nuisance. In any type of proceeding, as Michelle stated earlier, a predicate notice is required to be given to the tenant for non-payment of rent. It's a 14-day notice of non-payment of rent. And what we saw with the CARES Act was for any federally subsidized housing or any housing that was backed by a federally subsidized mortgage, that 14-day notice requirement was extended to a 30-day notice requirement. And for holdover proceedings, as Michelle did briefly state, it is dependent on the length of your tenancy. So if you've been there for under a year, you would only be required to receive a 30-day notice. 1 year to 2 year, a 60-day notice. Over 2 years, you must get a 90-day notice. That notice period has to expire before the landlord can initiate a holdover proceeding. For nuisance or breach of lease, the landlord can initiate a proceeding on a 10-day notice. And just with that, you want to check your lease to see if there's any type of cure provision, meaning the landlord would have to give you a notice to cure. And just a brief example of that would be if the unit you rented didn't allow for pets and you got a dog, if the landlord gave you a notice to cure and you got rid of the dog within 10 days, that would be a cure. So you want to check your lease for that. And then in any kind of proceedings, you can raise defenses. And then if there are any defenses that raise a question of fact, the court would then have to hear or schedule and hear a trial. In non-payment proceedings, some of the defenses that we typically see are if the rent has been paid or if the landlord is charging more rent than is legally allowed. And just quickly with the ETPA, Emergency Tenant Protection Act, the rents for those units are governed by DHCR, the Department of Housing and Community Renewal sets the rents for each year. So if the landlord was charging more than allowed by DHCR, that could be a defense as well. And then, we have some examples down here. The tenant has a Section 8 voucher. The tenant has been paying their share, and the landlord has not received the Section 8 voucher. The tenant is not responsible for the Section 8 voucher portion. And also the tenant is not responsible for anything above what Section 8 has approved for the base rent of the apartment or for the tenant's portion. And I believe now I am passing the baton to Alexandra Schweitzer.
Hello, everyone. My name's Alexandra. I'm a general practice attorney from LSHV. I'm going to try to go quick without speaking very loud as well.
Thank you.
You're welcome. So in a non-payment proceeding, the court can do two things. They can enter a money judgment and a judgment of possession. Judgment of possession gets the apartment back. Money judgment gets the apartment back if you don't pay that money judgment. So when a judgment isn't paid and you're evicted or you move out before the eviction date, the now former landlord, the old landlord, can seek to enforce that judgment. And sometimes they do many years after the fact. So these judgments are like any other civil money judgment, like Alex said, medical bills or credit card company bills. So there are some people such as SSI, SSD, retirement benefits, pension. Those types of people are exempt from enforcement of that judgment. We call them judgment proof. A person who works can be subject to wage garnishment. It's approximately 10%. So a person with a bank account with non-exempt funds, so such as SSI or SSD, they're protected up to $3,120 and 90% of the wages earned in the past 60 days. You can enforce a judgment 20 years later and it accrues 9% interest. So this negatively impacts credit And it also negatively impacts your future renting options because landlords can sometimes see that you have poor credit and don't want to rent to you. So anyone who receives a notice about a debt from a former landlord, it should not be ignored. You should definitely attend court. We have a Claro program that also helps with these types of issues. And as long as we haven't represented the tenant in the underlying action. In a holdover proceeding, this means like you want the landlord wants the apartment back. Alex talked about nuisance. The landlord has to serve a notice. It has to be very, very specific that the tenant can defend against these allegations. For example, an example of a nuisance could be your dog is barking, you assaulted another tenant. Anything that is regarding health and safety is most likely going to be considered a nuisance. As for repairs, if a tenant makes a good faith complaint to, say, the buildings department or the Department of Health, or any other government agency, really, the landlord cannot evict them based on this because it's a retaliation claim. This law was strengthened a lot in 2019 with the Tenant Safe Harbor Act. So in a holdover proceeding based on nuisance or breach of lease, the landlord has to prove what the tenant did or did not do. They can't just say it and then it makes it so. They have to prove it at trial. And a little caveat is there's a cure period. So if a tenant has a barking dog or the tenant wrote all over the walls, you can cure this. You can repaint, you can get rid of the dog, or you can muzzle the dog, anything like that. So there's a cure period after trial, even if you lose the trial. Okay. Every tenant is entitled to a safe and livable home. It's called the warranty of habitability. This is a defense in holdovers and non-payments. A landlord cannot put language in a lease that undermines this right. There are state, local, and county regulations that state what a building has to have in order for it to be rentable, for someone to rent it.
rentable, para que la
If a landlord provides heat, the dwelling must be 68 degrees at least. The hot water must be available within a certain temperature range. A tenant is entitled to have the landlord make repairs that affect health and safety, i.e. heat and hot water, fixing any leaks, toilet, any essential services. Any tenant who requires repairs and asks the landlord or their agent, such as the super, or contacts the building department, has the right and the defense of retaliation if brought to court in an eviction proceeding. And I'm going to hand the baton to Jason from HVJC.
And Jason, can I ask just if you could go quickly? I'm sorry, but I want to make sure that everyone gets a chance for their questions and Blanca gets to speak.
Will do. So there's a lot of money out there to help people. New York State passed the Emergency Rent Relief Act. People can apply for that through the Division of Homes and Community Renewal. The criteria is a little complicated, and the way that landlords get paid is a little complicated. People should probably contact LSHV or my office for more details about that. Tenants who are in arrears can also contact their local Department of Social Services. The DSS offices can usually pay 4 to 6 months rent. That's only available for citizens or households that have citizens, in the household. They can help with a portion of the arrears. The CARES Act, freed up a lot of money for arrears, and that's been distributed. My office actually got some of the CARES Act funds. So, that's been distributed out there through various agencies. So people should, people can contact my office. We can help tenants apply to all of the nonprofits in Westchester County, basically. through a kind of unified intake that we've collaborated on. But basically, all we need to know is that there is money out there for people. People should apply if they think they're eligible at all. I'll just say a quick word on undocumented immigrants. The laws and defenses that we've been talking about here apply to all tenants, all people in New York. A person's immigration status does not affect your defenses and your rights as a tenant. So everyone should be aware of that. An eviction or a money judgment against a tenant does not affect their citizenship status or their ability or eligibility for citizenship. Receiving assistance from one of us will not jeopardize your citizenship or eligibility under the under any of the I'm blanking on the word now, the public charge rule. This assistance will not trigger any kind of public charge consequences, so people should be aware of that. And you should contact my office. Again, we are the only office that's able to provide representation in landlord-tenant court for undocumented citizens. That is a real shame, we think. There's only 2 attorneys here. Please contact us if you would like to support our work, because we think that there's a lot of undocumented folks and the need is there for more representation. And I will just say a quick word about the Westchester County Right to Counsel Coalition. We're a group of a lot of nonprofits, faith leaders, legal services providers, and we'd like to see Westchester County pass a law similar to the law that was passed in New York City. In New York City, they're working on rolling out a program where everyone that's below a certain income level is provided with an attorney for free. We think an eviction is such a monumental event in a person's life that they should be provided with an attorney. People who are facing criminal charges, whose liberty is at stake, they get an attorney. We think eviction should be treated similarly. We've drafted a bill and we've presented it to the legislature. No one has endorsed it yet, but they have agreed to fund a cost of benefit study, which we think is really great. We know that a right to counsel program would offset a lot of costs. It costs a lot of money to house people in homeless shelters. It costs a lot of money to bus children to school districts whenever their family is evicted. So we really think that we need to find out what the real cost of that's going to be. And if anyone would like to get involved, we have a website with a petition. It will help you contact your legislator. And you can also send an email to rtcwestchester@gmail.com. I guess that's, I think I've said enough about that, and maybe we can move forward.
Okay. So 2 things. One, are we up for Blanca yet? Yes, okay.
Yes.
And so I want to be clear that some people would like to see the PowerPoint. I know Blanca has one as well, so I'd like to be sure we can share that, and Blanca's going to start hers. There's a number of questions in the Q&A, some in the chat. I will get to as many as I can after Blanca goes through her presentation.
Thank you. Thank you, Senator. Thank you to your staff and to my colleagues who have provided a wonderful presentation, a lot of good information for tenants countywide. So what I want to talk about has to do with programs, some programs and services that are primarily funded by the county to be able to assist renters who may be facing foreclosure, rental evictions. We are right now kind of at a stage where we are looking to design new programs based on the stimulus money that we're about to receive. And I'll talk a little bit more about that towards the end of my presentation. So there are 2 main eviction prevention programs that we have for residents living in consortium communities. In a second, I will show you the names of these municipalities that are part of the Urban County Consortium. These are towns, primarily towns and villages. We do have now who has joined the city of Peekskill that have 50,000 people or less in their municipalities and therefore cannot receive federal funds directly. So because of this issue, the Department of Planning acts as an administrator. So the Department of Planning receives money from HUD And based on an application process, they're able to distribute funds to the different municipalities that belong to this consortium. For more, and the funds that we have available through the Emergency Solutions Grant is available until April of 2022. And I've put the website there for more information if anybody wants to look at this in the county's website. So we had released an RFP last year once we received these funds, and we awarded funding to 4 different nonprofit organizations. These organizations provide rental arrears, utility arrears for households in these consortium communities. So these are the organizations are Community Housing Innovations, otherwise known as CHI, Washingtonville Housing Alliance, Choice of New Rochelle, and Westchester Residential Opportunities. These funds are for eligible households that earn no more than 50% of the area median income. So for a family of 4, we're talking about $62,900. Mind you that the area median income guidelines change on a yearly basis. So we should be receiving new information come March or April of this year. Funds will cover up to 4 months of back rent. Like I said before, utility arrears, co-op or common charges are also accepted. And again, the key is that the arrears have to be tied to the COVID-19 pandemic. Another important thing to note is that tenants must be within 21 days of eviction and also must show the ability to pay moving forward. So that if these funds can assist for the household to be stabilized, knowing that they will have money to pay future rents, then they should be eligible to receive the funding. If they're approved, payments are made directly to the landlord or management company, and a DSS denial is needed. So households do have to go to DSS, or applicants have to go to DSS. However, they have to be denied because they do not meet the program criteria of DSS. If they're denied because their application is incomplete, that's not a denial. So when people are going to DSS to apply, they have to see why they're being denied. It's really important for them to know and understand the reasons why they're being denied. And these organizations will certainly request for additional documentation to prove of the issue that the rent arrears is tied to the COVID-19 pandemic. We have, and unlike the program that I just mentioned, we have the medium term rental assistance, and this program is run directly from the Department of Planning. The contact for this program is Amy Morabito. I put her phone number and her email. And initially when this program was created last year, it was really to assist or aim to assist those individuals and their families whose jobs were in the phase 4 of their reopening plan. So obviously this plan was really to help these eligible renters to pay their rent while they were waiting for phase 4 to occur. Obviously things have changed, and therefore we have tried to change the parameters of this program so that we can assist households who were current up until March 31st, 2020, but then fell behind, obviously, because of the pandemic. Since we can pay up to 12 months of rental arrears or moving forward with their rent assistance, the landlords must sign a contract with Westchester County, and DSS denial is not needed for this program. So for anybody who wants an application or wants more information, I've included the link, but also please call Ms. Morabito for more information. This is a list of all of the municipalities in the consortium communities. Just so you know, as of 2021, we have 3 additional municipalities. However, they unfortunately are not eligible. The residents living in those municipalities are not eligible because this is only focusing on the municipalities that joined and were members as of 2020. I highlighted the communities that represent your district, Senator. If I'm incorrect, please let me know. But I think I was able to catch.
Bedford. I have Bedford.
Great. And then I want to talk a little bit about the assistance that's available through the Department of Social Services. Before I go into the programs, though, I want to take a step back and kind of let you know where the district offices are. Obviously, DSS has offices in Mount Vernon, Peekskill, White Plains, and Yonkers. You don't necessarily need to live in a particular region of the county to go to a particular district office. You can go to any of the district offices that they will see you. But obviously it just makes sense to go to the ones that are close, that is closest to you. As you can tell, they all have the same phone number, 995-3333. And while they're open to the public right now, we do suggest that either you call first, or if you must go in person, to please go if it's an emergency issue and you need to be seen on the same day. And there are also many different ways to get an application. Obviously, if you need to go, it's an emergency, you can go in person, get an application, fill it out, hand it into a DSS screener. And if you have the supporting documentation, they will see you depending on what it is that you need. Residents can also call DSS to receive an application by mail if there is time for that. They can also find the application online, so they can fill out the form and go into mybenefits.newyork.gov. They will have to create a username and password, but once they fill the form out online, it could be submitted electronically, and then they will be contacted by DSS. The other way to do it is you can also print out an application. I've provided the link, the PDF link, and I'll be happy to share this presentation as well. And then you can print it out, fill it in, and then go in person with the application and any supporting documentation you need to provide as well. We always get questions as to why, the application is so intensive. It could be a bit burdensome at times. And it's important for people to understand that while you may be going for rental assistance or you may be going for a specific issue, that application, the screener sees it as a screening tool, right? So there might be additional services or benefits that you or your family could be eligible for, whether it's SNAP, which is food assistance, whether it's Child Health Plus, which is health insurance for your children. Maybe you're eligible for Medicaid. So it's important that people understand that, yes, they're applying for a specific service or program, but that they're also reviewed and screened for additional assistance that their families may benefit from. So with respect to the eviction prevention programs Jason had mentioned in his presentation, low-income residents may be eligible for either emergency assistance or temporary assistance. The emergency assistance is for adults or families that are at 125% of the federal poverty level. So to give you an idea of what that means, for a family of 4, that means you can't make more than $32,750. And again, these levels change on a yearly basis, or could possibly change on a yearly basis. The other assistance is the temporary assistance, which offers 2 major programs. There's family assistance, which provides cash assistance to eligible needy families. And the program operates under the guidelines of TANF, which is temporary assistance for needy families. Eligible adults are also can only receive this funding for 5 years in their lifetime. So unfortunately, if you are past the 60 months, you may have to pay that money back, or you may be eligible for other services that is not cash assistance. The second sub-program is the safety net assistance. And this provides cash assistance to, again, eligible needy individuals and families who are not eligible for the first one, the family assistance. The slide explains to you who is eligible. Immigrants who are eligible for temporary assistance, but who are not eligible for federal reimbursement may also be eligible for the safety net assistance.
Look, I'm sorry to interrupt. If I could just jump in. I think when I was talking about DSS, I said that only immigrants are eligible for that, but that's obviously not correct. Other categories are eligible also. Sorry, I just wanted to point that out. I correct myself.
No problem. And I wanted to talk a little bit about the federal housing funds from the 2021 Stimulus Act, which was signed into law a couple of weeks ago. Counties and municipalities with population of over 200,000 people are eligible to receive funding. While we were not notified directly by Treasury, we were informed that the county would be receiving approximately $23 million in the city of Yonkers, $6 million. These funds will be available until December of this year, and they have already given us strict guidelines as to how we can and cannot use the money. So it can go towards assistance for rent, rental arrears, utility arrears, or other expenses related to housing due to the COVID outbreak. Assistance provided can be for no more than 12 months of rental arrears. And in some cases, we can also provide assistance, rent assistance. So if they need to, if we've paid, let's say 12 months, and now we're in February, we can possibly pay 3 months moving forward, depending on the situation. And the eligibility is for individuals who qualify for unemployment benefits, who have experienced a reduction of income, who have experienced significant costs or financial hardship directly or indirectly due to COVID. Requirements, they must demonstrate risk of experiencing homelessness or housing stability, such as a rent bill, a court notice, a rent notice, an eviction notice, or that they're living in unsafe or unhealthy living conditions. And the income eligibility, while the guidelines say that we can assist people who are at up to 80% of the county's area median income, which for a family of 4 would be about $100,640. We have to prioritize families and individuals whose area median income is at or below 50% of the area median income. Again, that would be half approximately. So again, with the family of 4, extra sample that I was saying would be about $62,900. So what are the county's next steps? We want to develop a comprehensive plan to address eviction prevention and rental assistance. You know, while this session is primarily focused on tenants, and we see that tenants are being impacted, we also have to be mindful that there are landlords and smaller landlords who are also impacted by this, and they're facing hardships as well. So the programs that we want to develop and we want to extend, because we did have a landlord program last year that we used with COVID funds, we are going to look at our portfolio and address and develop programs that will address any gaps in assistance. So in order to do that, we are going to have a summit with the local housing organizations. We plan on doing this more than likely at the end of January, early February. It is important for us to be able to talk to those housing organizations that are at the forefront, that are talking to families who have fallen behind, who possibly already have a waiting list of names of eligible candidates who are in need of rental assistance, but unfortunately at this moment there might not be a program that can address their needs. We're also in constant communication with their friends at HCR. We receive updates as to how their program is going, and possibly if there is, as their program comes to an end, if they still have applicants from Westchester County that we may be able to assist, we want to make sure we work in tandem with them to make sure that we're providing as much assistance as possible to households who may be eligible. And we also plan on releasing an RFP to obtain proposals from housing organizations, primarily obviously focusing on eviction prevention to vulnerable populations. So we are conscientious of the fact that we need to assist our households who are undocumented, and we plan on, and also focus on homeowners who are facing or who may be at risk of facing foreclosure, not just in homeowners of 1-unit families, but also 2 to 3 multifamily homes as well. And there's my contact information, and I'll be happy to answer any questions. Thank you.
Thank you so much, Blanca. And I'm going to try to pick and choose and do the best I can in going through these questions because we're near the end, but I want people to get questions. So there are a number of questions from either small landlords who have tenants with problems, or in one case, attorneys for landlords, where there is a tenant who has not paid rent in over a year, in other words, started prior to COVID, and then are abusing the COVID laws not to pay rent and refuse to apply for rent relief. So the bill that was described that we passed at the end of December attempts to find a compromise with respect to tenants who are problems, and also by requiring tenants when they sign the hardship declaration. I don't think this point was made as clearly as I'd like. When you sign this declaration, you have to say you are signing and submitting this form under penalty of law. This means it is against the law to make a statement on this form that you know is false. So if you are going to fill out this declaration and thereby basically make yourself, with some exceptions, immune from eviction for this limited period of time, you have to sign that. And secondly, someone asked this question of what is a nuisance under this law, and it's described as a tenant who persistently and unreasonably engages in behavior that substantially infringes on the use and enjoyment of other tenants or occupants, or causes a substantial safety hazard to others. And then there are other provisos. So every case is obviously decided on the facts. And I understand problems with landlords who have had tenants who prior to COVID weren't paying, and then by virtue of this law can't evict as quickly as they would otherwise. The bill expires in May. That was a compromise. Some of you may remember there was a proposal for a years-long moratorium. It was shortened because there is a reflection that hopefully we will be out of COVID and people will have some economic ability to pay. And the second thing I want to point out is the law is complicated. It's quite long. And as was pointed out earlier, attorneys will go through it and make their arguments to the court. And it was pointed out by legal services, I believe in March, many existing proceedings are at least going to either be conferenced or there will be an opportunity for both sides at least to make a case. So again, the effort in this bill was to be sensitive to the fact that there are many tenants who can't pay, and there are some landlords who are taking advantage. And at the same time, we try to protect small landlords by providing that they were immune from foreclosure and tax lien sales. So because courts are generally closed, there's not a real opportunity for the millions of tenants in New York State to all have their cases be heard. So this was a short-term solution. And I just wanted to answer that one the best I could. And I'm sure some of the attorneys from legal services may have others, but there is a question here. We've heard some courts have denied accepting the hardship form in other parts of the state. I'm not aware of that happening in Westchester. Can anyone speak to that? Is anyone aware of the form not being accepted?
No, I have not heard that in our Westchester, or even from my colleagues in other parts of the state.
Okay, and I apologize for going fast, but I'm going to try to, some of these I'm going to answer. There's one here that I think is quite important from Yonkers, and I do represent Yonkers. I don't see it, but I'll try to, here it is. If a company is buying off small buildings and evicting the tenants who have been living there for years by raising their rent 140% after a month with the building being purchased and refusing to provide leases, to immigrant community, mostly Hispanic. Within 2 months, the tenants received an eviction notice or a court notice to leave the premises. What information can you provide to further tenants that they will not be removed? And I will explain it by saying that the court is going to require that a person be served with this hardship declaration form by either the landlord or the court itself before it will entertain the filing of an eviction proceeding. Am I correct?
Yep.
So in other words, every one of those tenants is entitled to this form that was described in detail, and which there is a copy available, and they must fill it out indicating that they can't pay because of COVID or they have these other circumstances and they will not be able to afford to stay. And if the court receives that, unless there is this nuisance alleged, the eviction will not proceed. So this bill was intended to protect against the kind of intimidation that frequently forced people to move even without the serving of a formal eviction proceeding. I would ask the legal services people to clarify if I got that.
Senator, I'd just like to clarify. In my presentation, I spoke about notice being given 30, 60, or 90 days.
Yes.
That notice also needs to be given if the landlord intends to raise the rent over 5%. So if you've been there for over 2 years and the landlord intends to raise the rent 10% or 140%, you need to be given written notice 90 days in advance of the effectiveness of that increase. And then also, if you think these increases or lack of being given a renewal lease has to do with your status, you can also look into some form of a human rights complaint.
Another question, do these rules apply when a person is renting in a private house?
Yes.
Who answered that? Marcy, did you?
Mhm.
You want to speak to that?
Yes, so they don't differentiate. They do apply.
The word tenant is described basically as someone living anywhere, unless you are living in like a vacation house that someone else owns and then they come back to. Short of that, it applies to any tenant. Can this funding, I think this is a question for I'm going to leave some of these questions to the end. There was a question about the right to counsel initiative. And my understanding is the County Board of Legislators put in enough money for a study, correct me if I'm wrong, Blanca, to determine whether this right to counsel, how it would work in Westchester and how much it would cost. I'm very favorable towards it. I believe we have to wait for the results of the study and the report. And then I believe the county executive and the county legislature will consider it. But if people want to weigh in, they should contact their own county legislator. Different than me, I'm a senator in the state of New York, and then there's assembly, and county legislator is who represents you in White Plains in the Westchester County Legislature, which is available online. Anything more on that from those who are involved in the right to counsel?
Well, I just like to say that the reason the study is so important because, like I mentioned earlier, we really expect this kind of program to result in offsets in costs. So if there are fewer evictions, fewer people going into homeless shelters, that's going to reduce the county's budget. Also, we know that attorneys, when they look at tenants' ledgers, there are oftentimes when fees and other charges that should not be included on the ledger are included on the ledger. And if we can get those reduced, that's less money that either the county through DSS or other organizations have to pay to keep the tenant in the home. We also make sure that the tenants are asserting their defenses under the warranty of habitability. So if there are conditions in the apartment that should result in a reduction in rent, we can get that balance reduced. And so basically, we really see this as a way of preserving housing and reducing costs for the county So but we couldn't really do that analysis ourselves. So it's really imperative that we have this study tell us exactly how much this program costs, because it might not cost, if you count all of the offsets, it really might not cost as much as it might seem at first if you were just to say how much is it going to cost to give everyone an attorney.
Understood. And I want to point out that we at the state level are working very hard to push the new Congress to enact a new stimulus bill that has money for tenants and landlords, including small landlords and larger landlords. We recognize the income lost has been a challenge for everyone, and we need federal help, just like we need federal help in education and in state and local government. Whatever money we got in the last stimulus, we tried to apply to flow to landlords. As I mentioned earlier, it didn't work perfectly, but we need money, and we need money so that tenants can remain in their homes and landlords can meet their expenses. What happens to landlords who sue tenants through tort suits? Okay, my legal services experts.
We don't handle tort cases in our practice, so I don't feel we're equipped to answer that question.
Okay, well then I will switch to the next one. Are there any exceptions to DSS restrictions on eligibility for public assistance or rent arrears based on immigration status? Blanca, maybe you can answer. Yeah.
So, you know, there's a lot of concern, as Jason had mentioned, about the public charge and undocumented immigrants applying because of the fear of, you know, their future in terms of their immigration status may be jeopardized or whatnot. There are different programs that are eligible for undocumented immigrants. For example, Child Health Plus, which is available to children regardless of immigration status. And even though in the application itself, you have to list all of your household members, obviously we are conscious that there are a lot of families that have mixed immigration status, right? So mom and dad may be undocumented, but the children are documented. And when I mean documented, I mean citizens or permanent residents. So it's important to include that information because your family may be approved for assistance based on who is eligible to receive that assistance, right? But I also think it's really important that when people are applying to DSS for housing related issues, that they should definitely talk to Hudson Valley Justice Center, or they should talk to a HUD-approved housing counseling agency. We have about 4 or 5 of those agencies throughout the county: Westchester Residential Opportunities, Community Housing Innovation, Housing Action Council, Human Development Services, and my mindscaping 2 more. But they can also provide assistance, and they have counselors that are trained to assist families who are facing eviction based on whatever local ordinances may be there, county laws, or state laws that can protect them as well, regardless of their citizenship status.
It's also worth pointing out that there are a lot of charitable organizations that can help undocumented people, Catholic Charities, United Way, sometimes, you know, I would really encourage anyone who needs assistance to just contact us and we can put them in contact with the Eviction Prevention Network, because a lot of the charitable organizations can help people without, you know, they don't, citizenship is not an issue for them. They might require a person to apply for assistance from DSS and be denied first in some cases, but there are still resources for undocumented people, and we hope that they seek that out because we see a lot of people flee these landlord-tenant proceedings out of fear of you know, retaliation, landlords calling ICE and things like that. And we really encourage people to you know, assert their rights, and we're there to help them.
I think this is a question for you, Blanca. Can this funding, I think this is from someone from one of the public housing authorities, an administrator, be used to assist residents, or maybe they're talking about the funding in the bill, to living in public housing or on the Section 8 program? I think she was talking about one of the programs you were discussing.
Sure. So the first program that I talked about with respect to the 4 nonprofit organizations that have funding, if I'm not mistaken, I'm pretty sure that it is eligible for Section 8 or public housing. However, with the second program that is run directly from the planning department, they're not eligible for that.
Okay, thank you very much. I'm trying to get things that are not specific to an individual, obviously, and that are more general. Someone asked a question about how a landlord can pay a mortgage and other bills. I explained at the beginning that the act we passed is a prohibition on foreclosure actions by a mortgage company. I would explain to people it's a little complicated. Most mortgages are held by federally chartered banks. Federally chartered banks are not regulated by the state. So the state can't say to them, you can't foreclose. But what we did is said to the courts, you can't proceed with a foreclosure or a tax lien sale. So even if you owe taxes and your municipality gives you a notice, they cannot proceed with the tax lien sale. And a bank, even a federally chartered bank, during the duration of this crisis or until May 1st, as far as this bill goes, they cannot proceed with a mortgage foreclosure action as well. So again, we're trying to, as they say, thread a very challenging needle here and keep people in their homes the best we can. And so I'm going to do one more question. Talk more about retaliatory case by landlords. I think the question is really about, could you describe what kind of retaliation is protected? In other words, they can't retaliate against you. Could you explain in the regular words what that's like?
The classic example would be bringing a court case to remove a tenant. So the tenant makes a complaint and maybe the landlord says it outright, and then they bring a court case. And often these might be the person had been a month-to-month tenant for quite some time, and that continued. And then after the assertion of their rights, they received a notice of termination. So the law also provides for substantial making things difficult for the tenant within their relationship as a landlord and tenant, right? The technical term is, substantially altering the terms of a tenancy, but that in more sort of lay terms, that's, imposing, difficulties on the tenant, making their tenancy a problem after they complained. And so the law that's been in effect in 2019, really since 2019, really changed what was there before, which, really the tenant really had to do so much more work in these cases. And we actually, I don't think any appeals court ever found in favor of a tenant on one of these cases under the old law. Whereas under the new law, it's more balanced the way that these cases would be defended in court.
But an example from a tenant's point of view, as someone who represents rental tenants everywhere, you call because there's not enough heat or not enough hot water, and then you're afraid the landlord is going to try to evict you for complaining to the city or the town or the village, and somehow that landlord's ability to operate will be jeopardized. You can't be afraid of that. You have these rights and they cannot retaliate, even pre-COVID, but now clearly in COVID, during this time, there is basically a moratorium subject to the exceptions we described, which is that you have to sign a declaration under penalty of law and you can't be a nuisance, which I described the words that are used in the law with some complications attached. Subject to those two things, courts are basically held off from evicting you and forcing people out of their homes prior to May 1st, and people are protected from having to find another home during the midst of COVID, which, as I pointed out at the beginning, has been deemed to be a health hazard in and of itself. And you think of some of the families that I represent, and in Yonkers, the southern part of New Rochelle, and Portchester, some of them in Mamaroneck. We're moving with kids in the middle of COVID, would be a tremendous health challenge and would pose real issues for our community. Again, I want to point out that, as you pointed out, I think a number of you, the law doesn't say you don't have to pay your rent. You have to pay your rent. And the landlord can get a money judgment at the end of the day for the rent you haven't paid. So this does not minimize that. We are protecting people in their home during the time of this crisis the best we can. So with that, I'm going to close and thank so much all of the fantastic speakers and lawyers and who really have contributed their knowledge. And thank you for your practical on the ground knowledge of what the courts are doing. Thank you to our two excellent interpreters. Thank you to Blanca Lopez and the County of Westchester and the County Executive's Office. Thank you to my staff for helping make this happen, Mary Ann Joyce and Emiliana Ulay. And thank you to all Westchester residents who are interested in our common good, because as I say, this is a moment of shared sacrifice. We all are having to sacrifice, and everyone is paying a price, either financial, emotional, health-wise. I had to get up and leave because my sister is in the hospital with COVID and the doctor called, and you know when the doctor calls, that takes precedence. We are all going through a challenging time. This is a time when we are asking everyone, step up, share, sacrifice. It's not perfect. All of us are going to have consequences, but we try in the legislature to do our best for everyone in our district. And I appreciate all of your expertise here today and your opportunity to share with us your knowledge and your experience, your passion and your advocacy on behalf of tenants. And thank you all. Thank you very much for participating.